Heard you mention a few minutes ago in response to some of the questions asked by Senator Grassley that it's the President's preference to work with Congress and that wherever possible he'd like to get Congress to agree with him to pass legislation that he would like. But, of course, the other side of that coin is something that the President referred to repeatedly last night in his State of the Union address, which is that if he can't get Congress to act, he'll go it alone. If Congress won't act the way he wants Congress to act, then he'll issue an executive order anytime he gets the chance. This brings to mind a concern that I've had as to whether or not sufficient analysis is being undertaken when these executive orders are issued. As you know, the Supreme Court has, since Youngstown Sheet and Tube versus Sawyer, and Justice Jackson's concurrence, and certainly since Dames and Moore versus Regan, when that Jackson concurrence was adopted by the majority of the court, it has tended to separate out executive orders into three categories. In Category 1, you have a situation where Congress acts pursuant to authorization by Congress. And that's where his authority to act with an executive order is at its strongest. Category 2 is where you have the President acting in the absence of either a congressional authorization or a congressional prohibition. Justice Jackson described this as sort of a twilight zone where it's a little unclear, it's a little murky. Category 3 is where you have the President taking measures that are incompatible with congressional command. And so I would ask, number one, is this analysis undertaken each time the President issues an executive order? And number two, what was that kind of analysis undertaken when the President, for example, announced on July 2nd of 2013 that he would not be enforcing the employer mandate of the Affordable Care Act throughout the duration of 2014, even though by law the employer mandate was set to take effect as of January 1st, 2014.
Before the President exercises the executive authority that he discussed last evening, and again, I want to preface that with, I think, the pretty clear indication from the President that he wants to work with Congress on behalf of the American people. In the absence of that kind of activity, as he's done with regard to raising of the minimum wage, he's used his executive authority to, well, will use the executive authority to raise the minimum wage for those who do business with the federal government. Those kinds of activities by the President are done after consultation with the Justice Department, and an analysis is done to make sure that the President is acting in an appropriate and a constitutional way. And those three categories that you talk about that we all studied in law school from Justice Jackson are among the things that obviously are a part of the analysis. Where the President's authority is greatest, at twilight zone, and then where the President's authority is weakest.